All right, we're all going to get started in a couple minutes. Just a couple housekeeping notes first before we all get started. Welcome all of you, first of all. Really great to have you all here for our kickoff with Professor Neily. I just want to thank him again for joining us today. Two notes on FedSoc for this coming semester. We are going to have to be taking all of our events this way via Zoom, via the webinar. This limits to about 100 people. So if in the occasion that we do have more than 100 folks show up, this will be streamed live on Facebook for the rest of our students. So that's note number one. Note number two, if you are interested in asking a question at the end, we're going to have about 15 minutes for questions. Please use the Q&A function at the bottom of your screen. That'll allow me to read the questions off to Professor Neily when we are ready for that. And then third, just as always, I do encourage anyone who is not currently a member of FedSoc Nationals to sign up. FedSoc.org allows you to sign up with the student membership, which is $5, gives you access for the year to FedSoc events, invitations, as well as the ability to vote in our chapter elections. Now I'm going to turn this over to Alex. He's going to be introducing Professor Neily.
Thank you, Sydney. It's my pleasure to introduce our distinguished speaker. Clark Neily is Vice President for Criminal Justice at the Cato Institute. His areas of interest include constitutional law, overcriminalization, coercive plea bargaining, and police accountability. Before joining Cato in 2017, Neily was a senior attorney and constitutional litigator at the Institute for Justice and director of the Institute's Center for Judicial Engagement. He is an adjunct professor here at George Mason's Antonin Scalia School of Law, where he teaches constitutional litigation and public interest law. Neily served as co-counsel in District of Columbia versus Heller, in which the Supreme Court held that the Second Amendment protects an individual right to own a gun. Neily received a Bachelor's of Arts in Plan 2 with concentrations in philosophy and Russian from the University of Texas at Austin. And he also received his law degree from the University of Texas, where he was chief articles editor of the Texas Law Review. He is the author of Terms of Engagement, How Our Courts Should Enforce the Constitution's Promise of Limited Government. Please join me in welcoming Clark Neily.
Thank you so much, Alex and Sydney. I really appreciate that. And I'm so excited to have the opportunity to speak to everybody today about, I think, one of the most important issues in the criminal justice area, and one that up until a few months ago, I think was really flying underneath the radar screen and not getting nearly the attention that it merits in terms of its effect on our criminal justice system. And I think my perspective is that we have a highly toxic and pathological criminal justice system. I've written a recent blog post in which I describe it as rotten to the core, which I believe that it is. And one of the central pathologies, in my judgment, in our criminal justice system is the doctrine of qualified immunity, which I believe represents the cornerstone of our near zero accountability policy for law enforcement. And I'll say that again. Qualified immunity represents the cornerstone of our near zero accountability policy for law enforcement. So the title of the event is qualified immunity, does it mean unqualified impunity? And the answer is very nearly. As I'm going to explain in a moment, qualified immunity is a legal doctrine that was invented out of whole cloth by the Supreme Court, whose primary role in our system is to ensure that police officers and other government officials who violate people's rights are able to get away with doing so. And I want to emphasize this point because this is a point that proponents, people who support qualified immunity, are constantly confusing and eliding. There are plenty of other procedural mechanisms that deal very effectively with genuinely unmeritorious lawsuits. Things like the motion to dismiss, various pleading standards, summary judgment, and so forth. Qualified immunity plays a very unique role in our system, which is to ensure that police officers who have violated people's rights are nevertheless able to do so and get away with it without being held civilly liable. And I think that's hugely problematic. Let me try to situate this doctrine of qualified immunity the way I see it in our criminal justice system. It is extraordinarily important that police and other government officials receive accurate feedback from citizens, from people like you and me, people who are not members of law enforcement, who are not part of the criminal justice system. It's vitally important that police in particular receive accurate feedback from ordinary citizens about what we expect from police in the way that they go about their duties. It has been pointed out, oftentimes by proponents of qualified immunity, and fairly, that police frequently find themselves in ambiguous situations, situations where they have to use a large degree of discretion, where the exact correct thing to do is unclear, the exact contours of a person's rights versus the duties of that police officer are also unclear. And my basic argument about qualified immunity is that it disrupts this extraordinarily important feedback loop that would otherwise exist, and distorts that feedback loop in such a way that police systematically receive inaccurate feedback and inaccurate information about what we as citizens expect of them. And I think that's a large part of the reason why we see such frustration and such an outpouring of anger in the streets, and have for the last several months, at least since the killing of George Floyd back in May. In large measure, this is because police are not receiving accurate information from the public about what we expect from police when it comes to things like use of force, including the use of lethal force by police. And I think that qualified immunity, as I'll explain in a moment, plays a central role in disrupting and distorting the feedback loop that is so vital in this area, so that police receive accurate information from the public about what we expect of them. And as I mentioned a moment ago, I think the qualified immunity distorts this feedback loop and ensures that police receive inaccurate information. And then, of course, that translates into their actual behavior in the field, which a very large chunk of society condemns, and I think rightly so. All right, so let's talk about the concept of accountability. When you clothe government officials with the extraordinary discretion and the authority that police officers have, they have the ability to make arrests. They have the ability to interfere with your freedom of movement, even short of an arrest. They have the ability to use force. We equip them to use lethal force. This is an enormous amount of discretion, and it's a tremendous amount of authority for one person to have. And it turns out to be extremely important when you clothe a government official with this level of authority and this level of discretion, to ensure that you also include accountability. In fact, accountability might be one of the most important things when you clothe public officials with the extraordinary amount of discretion and authority, raw power with which we clothe police officers. And it turns out there are really only three avenues of accountability in our system. The first is a criminal prosecution of a police officer or other government official for engaging in abusing their power and engaging in misconduct. The basic problem with that, and you hardly ever see it, you hardly ever see police officers prosecuted for criminal violations. One part of that reason is that it's not the case that every act of misconduct is also a criminal offense. But an even more important dynamic, I would say, is the fact that a prosecutor must decide whether to bring criminal charges. The victim of the police misconduct cannot make that decision for themselves. Only a prosecutor can make that decision. And prosecutors have a massive conflict of interest when it comes to police. They work with police all the time. They depend on police to bring them cases, and they depend on police to testify in those cases in order to enable prosecutors to get convictions. So it's a well-known fact that prosecutors have a massive conflict of interest when it comes to deciding whether to charge police officers with crimes, and it turns out that they almost never do it. Virtually the only time you will see a prosecutor charge a police officer with a crime is when the misconduct has been caught on a video that has gone viral, and there is so much public outrage that it represents a threat to the career of the prosecutor to fail to act. Short of that, prosecutors will almost never prosecute a police officer because they have a massive conflict of interest. The second avenue of accountability, or I should say potential avenue of accountability for police and other government officials, and particularly police, are internal accountability mechanisms. So here we're talking about things like internal affairs, being disciplined by your supervisor or the chief of police or a citizens review board. This avenue of accountability turns out to be not particularly viable for pretty much the same reason as the reason that criminal prosecutions don't work. And that is that with internal accountability mechanisms, you are in effect asking the police to decide whether the police did anything wrong. And perhaps not surprisingly, they almost always say no. Everything our officer did was just fine. And again, this is not difficult to understand the internal dynamics here. The police have a very obvious conflict when investigating themselves, and a very strong incentive to clear their fellow officers, which they almost always do. The other point about this avenue, this internal accountability avenue, is like the first one, the citizen has to depend on a government official to proceed with the accountability mechanism. Otherwise, the citizen is out of luck. So that really leaves only one, I think, truly viable avenue of accountability, and not coincidentally, the only avenue of accountability that can be both initiated and pursued unilaterally by the citizen. In other words, you don't have to convince some government official to initiate and pursue a disciplinary action against a police officer or other government official. And of course, I'm talking about the ability to bring a civil rights claim, particularly a civil rights claim under Section 1983, which is our nation's primary civil rights law. It's been on the books since 1871. It was enacted after the Civil War, in the wake of the Civil War, near the beginning of Jim Crow. It was called the Enforcement Act back then, otherwise known as the Ku Klux Klan Act. We now refer to it as Section 1983 because of its location in the US Code. Section 1983 in its operative language is quite straightforward, and it provides that any state actor, which means anybody who is employed by a state or municipal government, shall be liable to the person injured for the deprivation of any right. And let me say that again, because it's going to be very important in a moment. Section 1983, our nation's primary civil rights law, provides that a state actor shall be liable to the person injured for the deprivation of any right. Now, what happened was that in 1967, the Supreme Court took a sort of a small step in kind of judicially amending Section 1983 to create an exception for good faith, and a particular kind of good faith. The case is called Pearson versus Ray, and in that case, a couple of police officers had enforced a segregationist law that was at the time considered to be constitutional, and it was only later that the law was struck down, and then the officers were sued for enforcing a law that turned out to be unconstitutional. And the Supreme Court held in effect that it's not really fair to hold somebody liable for enforcing a law that they believed was constitutional at the time and that no court had struck down, and that only later is determined to be unconstitutional. Now, let me say this. That's a perfectly reasonable standpoint from a policy position. The problem, of course, is that the text of Section 1983 does not contain any language to that effect. So it was a small but significant judicial amendment to the actual text of Section 1983, which again provides that the state actor who deprives a person of their rights shall be liable. Full stop. The Supreme Court then massively expanded this exception to Section 1983 in a 1982 case called Harlow v. Fitzgerald, and this ushered in the birth of the modern qualified immunity doctrine. And what the Supreme Court held in Harlow v. Fitzgerald is that in order for a civil rights plaintiff to pursue a claim against a police officer or other government official, they have to demonstrate that the right in question is, quote, clearly established. And it turns out that these two words, clearly established, which the Supreme Court effectively inserted into the text of Section 1983, do a tremendous amount of work. And doctrinally, in terms of the way that the case law has built it out, what the clearly established requirement imposes on the plaintiff is the obligation to identify a specific case in the relevant jurisdiction where virtually the exact same thing was done to another person by another police officer, and a court has already said you can't do that specific thing. So it's not the case that you can satisfy the clearly established prong by simply identifying a case that says, generally speaking, you're not supposed to shoot an unarmed suspect or something like that. I have to find a case where the specific conduct at issue, the thing that was done to you, and I'll illustrate this in a moment with a real case, but this is really what gives qualified immunity so much of its power, and I would say makes it such a pernicious doctrine, is that it causes the outcome of civil rights cases to turn on a happenstance. namely whether there just happens to be a case already on point. Let me give you an example. One of the most interesting First Amendment issues that remains unresolved by the Supreme Court, at least for my money, is whether there is a constitutional right to record police officers in public. It is not at all uncommon to see police officers attempt to interfere with people when they're recording, either by ordering them to stop or making them back up to a point where they can no longer record the activity going on, and all kinds of other sort of tricks that Supreme Court or cops have come up with for discouraging people or preventing them from recording. The Supreme Court has not yet weighed in on this issue, and there's only about 4 or 5 federal circuit courts that have looked at it. All of them, by the way, have held that there is a First Amendment right to record police in public. But if you happen to find yourself in a circuit that has not yet weighed in on this question, and this is not hypothetical, there's actually a case going on in Denver right now where a young man was recording police in public. They came over, ordered him to stop, threatened him, demanded that he turn over the recording device. He later sued them for interfering with his First Amendment right to record police, and they asserted qualified immunity on the grounds that even though every other circuit that has looked at the question has said there is a right to record police in public, it just so happens that the 10th Circuit has not yet weighed in, and therefore the right to record police in public is not clearly established. That case is still going on, and I would say it's even money which way the 10th Circuit will go on that. The only reason I even give the odds as that close, 50-50, is because the police in that case have testified that they were specifically trained by their own department that in fact there is a right to record police in public and that they should not interfere with people who do so. But even with all of that background, I still think there's at least a 50% chance that the 10th Circuit grants qualified immunity and dismisses the case. So again, what is the role of qualified immunity in our system? And it kind of depends who you ask. If you ask a proponent of qualified immunity, if you ask a police officer, what they will usually say is that qualified immunity protects police from having to make sudden decisions in the field and not be second guessed later for making reasonable decisions in the field under conditions of uncertainty and oftentimes risk. That sounds very appealing. One could imagine that that would have some strength as a policy argument. Again, there's nothing in the text of Section 1983 that creates that policy, but you could imagine somebody arguing that such a policy would be good if it were embraced by the policy-making branch, which again is Congress, not the courts. But it turns out that's actually not the role of qualified immunity, because again, there are all kinds of other procedural mechanisms that are available to make unmeritorious cases go away. The role of qualified immunity in our system is quite different. The primary role of qualified immunity, I would say, is twofold. First, it is to discourage civil rights plaintiffs from filing otherwise meritorious cases. In other words, one of the things that it exists to do is to cause plaintiffs, and more specifically plaintiffs' lawyers, who are confronted with a meritorious case, a case where a police officer has engaged in conduct that one can be reasonably confident a jury will find has violated the victim/plaintiff's constitutional rights, but there happens to be no case law directly on point. And pretty much every study that has been done where plaintiffs' lawyers, civil rights plaintiffs' lawyers have been asked, they say that a very significant consideration for them in whether to take a case is whether the same thing already happened to somebody else in that jurisdiction. And if they can't find a case with functionally identical facts, then they are likely to not take the case and not file the case. Why? Because they can see what's coming down the road, and what's coming down the road is that the officer who engaged in the misconduct will assert qualified immunity. The plaintiff will then have an obligation to identify a case with functionally identical facts. They won't be able to do it. Motion will be granted, and all of the effort that went into the case will have been wasted. So qualified immunity's first role in our system is to discourage otherwise meritorious cases where there doesn't happen to be an existing case on all fours, identical facts. The second role is to let rights-violating police officers and other government officials off the hook, and that flows naturally from the first point. Qualified immunity is not something you need to assert if you haven't violated anybody's rights, or if you haven't engaged in conduct that you don't think you'll be able to explain to a jury, or that you think you will be able to explain to a jury. You don't need qualified immunity. What qualified immunity mainly enables police to do is to get out of responsibility, to avoid civil liability when they do violate people's rights. That's the primary role of qualified immunity in our system. And as I suggested at the beginning, I think that significantly distorts the signals that police receive from ordinary citizens like us. Let me give you a few concrete examples. These are all drawn from cert petitions that were pending in front of the Supreme Court until May of this year, when the court kind of did an en masse denial of about a dozen cert petitions involving qualified immunity and challenges to qualified immunity. First case I want to talk about is called Corbett v. Vickers. This is a case out of the 11th Circuit where police were pursuing a suspect through a residential neighborhood. They finally caught up to him on the front yard of this family's house, where the family happened to be outside on the front yard. The kids were playing. Police officer tackles the suspect, gets him handcuffed, and other police arrived. And they make everybody lie down on the front yard. Kids, adults, everybody, to get control of the situation. After the police officer who tackled the suspect has handcuffed him, the family dog walks out from underneath the house, not growling, not barking, not threatening anybody. The officer who has just handcuffed the suspect draws his pistol and fires a shot at the dog. He misses. Dog goes back under the house. A couple minutes later, the same dog emerges from the house again, not barking, not threatening. And the same police officer again draws his pistol, shoots at the dog, again misses, but this time strikes a 10-year-old boy who's lying on the ground a foot and a half away from the police officer in the back of the leg, severely injuring him. The family sues, and the 11th Circuit, in a 2-to-1 decision, grants qualified immunity and holds that that police officer cannot be sued, not because he didn't do anything wrong, but simply because we don't have that same case already on the books in the 11th Circuit. Another 11th Circuit case, this is a 6th Circuit case out of Tennessee called, this one is Baxter v. Brady. And this is going to illustrate just how close the facts have to be in order to avoid qualified immunity. This is another police pursuit case, this time involving a canine unit. So one of the officers has a dog. They catch up to the suspect in the basement of a church, and realizing that he's been caught, he sits down and puts his hands up in a position of surrender. There is then a pause of about 5 or 10 seconds while the suspect and the police look at each other, after which the police officer in control of the canine releases the dog and has it go and attack the suspect, biting him in the armpit, severely injuring him, requiring emergency surgery. He sues. Now, interestingly enough, he's got a case that's 2 years old from the 6th Circuit with nearly identical facts. Everything is the same. It's a pursuit with a canine unit. The dog bites the person who ultimately becomes the civil rights plaintiff. Here's the only difference. In the case that happened 2 years earlier, when the suspect finally submitted, he lay down on the ground with his arms at his side in a position of surrender and was then attacked by the dog. And the 6th Circuit said, no, that's a violation of his 4th Amendment right to be free from unreasonable seizure. But the 6th Circuit in the Baxter v. Brady case 2 years later held that there is a sufficient difference between a suspect lying on the ground with his hands at his side and a suspect sitting up with his hands up in a position of surrender, that those are not the same case, and therefore qualified immunity does apply, and those officers cannot be sued. I could go on, and I'll probably give some more examples during the Q&A, but that is the real face of qualified immunity in our country today. Those kinds of cases that I just described are where qualified immunity really does its heavy lifting, which is, again, to allow police officers who have violated somebody's civil rights to get off the hook and to avoid civil liability, not because they didn't do anything wrong, they did do something wrong, but simply because there's the happenstance of there not having been a pre-existing case with sufficiently identical facts in the relevant jurisdiction. And I don't think I have to, sort of elaborate or belabor the point to demonstrate how incredibly problematic this is, because think about what these police officers are seeing in practical terms when they are sued under Section 1983, which provides recovery for the deprivation of any right. So they're sued under the statute saying that if they violated any rights, they're going to have to pay. The judiciary then throws the case out, dismisses the case. If you're a police officer, what do you see? Well, I submit that what you probably see is a shining green light from the judiciary saying to you, you didn't do anything wrong. You don't have anything to worry about. There's no need to change. Now, that is certainly not the message that the judiciary intends to send, and it's not the message that the judiciary believes that it is sending, but it seems rather clear to me that it is the message that at least some police officers receive when a case where they have been accused of misconduct is thrown out on qualified immunity grounds. I think they draw the very reasonable conclusion that they must not have done anything wrong. And this perpetuates I think it helps to perpetuate this cycle of abusive and unaccountable conduct on the part of police. And instead of correcting their behavior, they continue to engage in behavior that exacerbates the conflict and the mistrust that I think we're, again, seeing spilling out into the streets. So the question arises, can this be fixed? Is there any solution to this? And here we have some hopefully good news. Unlike a lot of other problems that the Supreme Court has created, this one actually has two solutions. So again, this is not a constitutional doctrine. This purports to be a judicial interpretation of a federally enacted statute. And so the Supreme Court could fix the problem by simply disavowing the cases in which it judicially amended Section 1983 and simply say, Harlow v. Fitzgerald is overruled, Pearson v. Ray is overruled, and from now on, lower courts should apply the text of Section 1983 the way it was written by Congress, which is to say liability for the deprivation of any rights, and there's no longer a requirement that the right be quote unquote clearly established. The other body that has the ability to fix the qualified immunity doctrine, of course, is the Congress, because again, it does not purport to be a constitutional interpretation. It's just a statutory interpretation. And if Congress disagrees with the Supreme Court's interpretation of Section 1983, Congress has the ability to amend the statute and make clear that there is no qualified immunity defense. And in fact, some of you may recall that there was a very serious push in Congress this spring to do precisely that. Led by, among others, by Justin Amash in the House and Senator Mike Braun from Indiana. Unfortunately, there was no movement, as it turns out, before the recess on police reform or any other significant aspect of criminal justice reform from this spring. And so it remains to be seen what, if anything, will happen after the election and once we find out the composition of the new Congress. There is a kind of a third avenue that may have some effect, although I think we shouldn't lose sight of the fact that it's incredibly important to get qualified immunity out of federal civil rights law. But a number of states have been looking at the possibility of enacting what amount to state analogs to Section 1983 so that you can sue police and other government officials for the deprivation of any of your state constitutional rights. Colorado actually did just that this summer. Colorado passed a state version of Section 1983. So now you can sue police in Colorado or other government officials who violate your state constitutional rights, which turn out under the Colorado Constitution to be highly analogous to federal constitutional rights. And after specifically considering whether to include qualified immunity and having a day-long hearing in which various individuals testified about qualified immunity, including my colleague Jay Schweikert from Cato, the Colorado legislature decided not to include it, and the governor signed the bill this summer. A number of other states are looking at that as well. Unfortunately, just a few days ago, the Virginia House voted down a proposal to eliminate qualified immunity here in Virginia, so you still have to surmount it at the state level here. But I would say on balance that the movement, the momentum, is in a generally positive direction. It seems very clear to me, at least, that the public is highly dissatisfied, or a significant majority of the public is highly dissatisfied with the way that police conduct themselves, and particularly with their use of force, including lethal force, and that there is significant public outcry for something to be done, and specifically for something to be done about ensuring that the government officials that we clothe with this extraordinary amount of authority, this extraordinary amount of discretion, and who we are constantly sending in to engage in conflict with communities, including particularly communities of color, oftentimes enforcing laws which, at least from my perspective, really don't make the community any better. I'll give just one example. There were more arrests for marijuana possession in 2018 than for all violent index crimes combined. These are serious violent crimes like assault, armed robbery, and homicide. When you have police out in the field enforcing things like marijuana possession laws as vigorously as they do, that's going to create a lot of conflict. It's going to create a lot of tension, and it's going to create a lot of resentment. To then add on top of that this non-accountability policy that we have simply exacerbates all of those problems. And I'll finish by saying this. One thing that I'm seeing people beginning to realize, even if they couldn't articulate the exact cause, and they maybe don't even know what qualified immunity is that they are now realizing that when it comes to the amount of accountability to which we are held by members of law enforcement, police, and prosecutors, we, citizens, are held to an extraordinarily high level of accountability. Is in fact the case. You can be arrested, you can be prosecuted, and you can be convicted and incarcerated for engaging in conduct that you didn't even know was illegal. So it is actually true that ignorance of the law is no excuse, unless you're a cop. If you're a cop, then there's this whole legal doctrine of qualified immunity that lets you off the hook on the premise that it wouldn't be fair to hold you liable for engaging in conduct that you didn't know was a civil rights violation. So again, when we're talking about the level of accountability to which we citizens are held by law enforcement, it is extraordinarily high. But when the shoe is on the other foot, and the question is how much accountability should we get from members of law enforcement, police and prosecutors demand on a level of accountability that is extraordinarily low, far lower than the amount of accountability to which we are held, which gets it exactly backwards. When you are clothed with the kind of discretion and authority that police and prosecutors are clothed with, you should be held to a very high level of accountability. But they have insisted, so far successfully, that police, prosecutors, and other government officials be held to an extraordinarily low standard of accountability. And again, qualified immunity represents the cornerstone of our near zero accountability policy for law enforcement in this country. And it's time to get rid of it because it really is hugely distorting the feedback that we depend on in order for police and other government officials to understand what is expected of them and what we insist upon when it comes to respect for people's rights and for their physical safety. So with that, that's qualified immunity in a nutshell, and I look forward very much to your questions. Thanks again for the opportunity to do this event and speak about this important topic with you. And we'll take questions.
Thank you so much, Professor Neily, again for joining us. Let me go ahead and pull up our questions. All right, our first one comes from Cody. Have there been any more denials of qualified immunity on a case-by-case basis over the last few months? I.e., does it look like courts are acknowledging the pressure of the current climate and refusing to grant QI in more cases?
That's a great question. I appreciate that. So, in a nutshell, the question is whether the courts appear to be sort of responding to the public outcry and condemnation of qualified immunity. I think you could make a case for that. It's always dangerous to sort of try to judge trends just on the basis of kind of a small snapshot in time. But I feel like I've been seeing courts deny qualified immunity in cases where they might otherwise have granted it. The one thing I can absolutely say has been a trend has been the willingness of lower court judges to heap derision and scorn upon the doctrine of qualified immunity. I've been a public interest lawyer for more than 20 years. I've worked on things like civil forfeiture, eminent domain, and I've never seen anything like this. I've never seen a doctrine or a, kind of a legal institution that judges were more willing and in fact more inclined to deride and criticize in their written opinions. So what you'll see sometimes is a judge will grant qualified immunity. This happened in Mississippi recently. A district court judge granted qualified immunity because he felt that there was no case sufficiently on point to make the right at issue clearly established. And the rest of the opinion, which goes on for more than 20 pages, is just a screed about the doctrine itself and the harms that it creates. There was a Fourth Circuit case, I would say 6 weeks ago, in which they denied qualified immunity in a police killing, in a case where police killed a homeless man. And there's a passage in the opinion where they said, this has got to stop. And they're referring in particular to qualified immunity. So is there a trend? I'm not sure. I think there could be in terms of what courts are actually doing in terms of the outcomes, but there absolutely has been a trend in terms of the willingness of judges to criticize qualified immunity and call for the Supreme Court to revisit it.
All right, thank you. Our next question comes from Mary. Could you talk any more about the Reforming Qualified Immunity Act introduced by Senator Mike Braun? What do you think about the proposal, and is it good enough?
I'll take the second part of the question first. Any improvement in this area is, I hate to say not good enough. I'd say any improvement should be embraced. I'm somewhat skeptical that this problem can or will be solved kind of in one fell swoop. I wish it could, but that's just not usually the way Congress works, and it's not usually the way that the Supreme Court works. So from that perspective, I think Senator Braun's bill was excellent, and it did largely provide for the elimination of qualified immunity, although if I recall correctly, it retained a fairly narrow exception for acts of genuine good faith. In other words, if a police officer could point to some pre-existing case or statute that authorized or purported to authorize the conduct at issue, then they would have a safe harbor for that. And I thought it somewhat elegantly, turned the table so that right now, as a civil rights plaintiff, it's incumbent on you to find a case that says that the officer shouldn't have done the thing. Had Senator Braun's bill been enacted, that would have turned the tables and put the onus on the police officer to find a case or statute that specifically said what they did was okay. And I would have been fine with that. I don't think that would have done a whole lot of, wouldn't have been a very pernicious exception or defense to have in the law, because it seems to me that it would hardly ever come up. So I think it's a real shame that there was significant Republican opposition to Senator Braun's bill, which was, I think, a very measured and very thoughtful response to something that I'm just amazed at how many people, and specifically legislators, seem prepared to ignore, which is the outpouring of anger and frustration that we've been seeing in the streets, and specifically about the way that people are policed. There has to be a response to that, and I'm shocked and deeply disappointed that so far Congress has chosen to turn a blind eye instead of upholding its responsibility to legislate when there's a problem.
Thank you. Our next question comes from Jacob. How have courts changed the consideration given to the rights drawn out in the 4th, 5th, and 14th Amendments, warrantless search and seizure, due process clauses, regarding qualified immunity cases? The case law post-U.S. versus Jones shows a swing back toward protecting citizens' rights in some regards, and could changes in state laws be used to evaluate future changes for qualified immunity?
Yeah, there's a lot to unpack there, and I appreciate that question. I guess what I would say is that I'm not sure that I accept the premise of the question. When I look at the Supreme Court's 4th, 5th, and 6th Amendment jurisprudence, specifically with respect to policing and criminal procedure, I do not see either a kind of macro or even a micro trend kind of in a positive direction. I'm not saying that there haven't been any favorable cases. I'm talking here about an actual trend. I think the general perspective, and certainly one that I share, is that the 4th Amendment has been largely shredded by the Supreme Court, and within the environment of the war on drugs, which has been, I think, a real driving engine behind the denigration of constitutional rights. But we've also seen, I think, a really significant undermining of many other rights of criminal procedure. And then, of course, all of this ends up getting processed through what you might think of as kind of the magnifying glass of qualified immunity. In other words, it's bad enough that the Supreme Court has generally been increasingly indulgent towards the use of various police techniques in the field, but then it layers on top of it this qualified immunity defense that ensures that none of these close cases, or very few of these close cases, end up being resolved by a jury, which is really, I think, the ideal mechanism for resolving most of these cases, because then both the police or other government defendant and the plaintiff in that case are getting feedback from the community about what we expect. And by the way, juries remain highly favorable to police, both in criminal and civil cases. So the idea that police would be destitute if we got rid of qualified immunity is wrong on so many different levels, but including that having an opportunity to explain your conduct to a jury that tends to be, in most jurisdictions at least, favorable to the law enforcement community, I think is not some unfair burden. I'll add one more thing. This idea that if we got rid of qualified immunity, we would have what amounts to a strict liability regime is a pernicious perspective that some people in law enforcement have tried to convince legislators would be the case. That's not true. Most of the constitutional provisions at issue here contain a reasonableness standard. So you think about the 4th Amendment. The 4th Amendment prohibits unreasonable searches and seizures. And what that means is that in a use of force case, for example, which falls under the rubric of unreasonable seizure, the officer is going to have an opportunity to explain to a jury why he or she considered their behavior, the decision they made in the field to be reasonable. And again, in an environment where most juries tend to be, to give police considerable leeway, the idea that you should have to go in front of a jury and explain why you shot somebody, why you used force against them when they were handcuffed, why you used a technique like a chokehold that's been banned by your department. I just don't consider that to be unduly onerous. And I think that we as citizens are owed that explanation, and we should put police in a position where they have to explain why they did and what they did to a jury of their peers more often than we do.
Thank you. Our next question is from another Jacob. Some proponents of QI might argue that because the police often end up in adversarial relationships with the public, giving tickets, making arrests, etc., this exposes them to a greater than average risk of being sued even when they don't misbehave. Given the low average salary of the police, how should society deal with this? We want to hold the police accountable, but do not want to make responding to these kinds of suits cost prohibitive. Should the state still defend police in suits without QI?
Right. So there's appreciate that question. There's a couple of really important points in here, and I'm going to try to kind of keep them discrete because it's important to be clear what's going on. The first point that I would make is I suspect that most of the people in the audience have never filed a federal civil rights lawsuit. I've done that a bunch. I used to be a litigator at the Institute for Justice. I was there for 17 years. That was my bread and butter, was filing Section 1983 cases. It is not easy. It takes a lot of effort to put together a complaint that will survive a motion to dismiss. In some cases, it can even be a challenge to put together a complaint that will survive a Rule 11 motion for sanctions when you're trying to litigate a sort of a cutting edge area of the law. And the idea, and I would say that virtually nobody has the ability to litigate a federal civil rights case pro se. So if you were to try to go and file a case on your own, the chances of it getting thrown out immediately are very high. So effectively, what would-be civil rights plaintiffs will have to do is convince a civil rights lawyer, whether a private one or a pro bono one, to file the case. And that's not easy to do. These people have other things they can be doing. Most of the people who know how to do this work have other things they could be doing. So you're going to have to usually have a good case. And I mean, not just meritorious, but a case involving some significant amount of damages or some significant legal issue in need of resolution. And I just don't believe that there's going to be, sort of people running around filing federal civil rights cases willy-nilly. It just doesn't happen that way. On the other point about police officers not being paid that well and exposing them to liability, I have a proposal, and others have independently come up with similar proposals, and it's very simple. What we should do, I believe, is eliminate indemnification. There's a 2014 NYU Law Review article that documents that 99.98% of all dollars paid out in civil damages awards against police are in fact paid out not by the officer who engaged in the misconduct, but by the department, by the city, which ultimately means by us, the taxpayers. Again, 99.98% of all dollars paid out in federal civil rights cases are paid out by effectively us, the taxpayer, not the officer who engaged in this conduct. I think that gets the incentives exactly wrong. And what I would propose to do is eliminate indemnification, take some of the money that is currently being used to pay out these civil damages awards, and instead provide it to individual officers in the form of a stipend with which they can then go and buy professional liability insurance. Just like you'll have to do as a lawyer, just like my sister who's a doctor in Maine has to do, just like all professionals do. You go and buy your own professional liability insurance. And the beauty of this is that we can make this happen with no dollars out of pocket by the individual officers. They can be given an amount of money that will enable them to purchase professional liability insurance. And then instead of we, the taxpayers, paying for their misconduct, their insurance company will have to pay those damages. And the insurance company will then turn and exert pressure on individual officers who are also their policyholders to behave better in the future. And the really bad officers, the so-called bad apples, will eventually become uninsurable because their premiums will get so high that they can't afford insurance anymore, or they won't be able to find an insurer who will even agree to write them an insurance policy. And guess what? When they become uninsurable, they will also become unemployable after a track record of misconduct. And what could be better than that?
All right, thank you. Our next question is from Professor Soman. As you likely know, qualified immunity applies to a wide range of other government officials as well as law enforcement officers. Do you think it should be abolished for all of them? And if not, how should courts decide where it should be preserved?
I appreciate that question, Ilya, and I appreciate you participating in the event. That's a great question. I mean, I think that you could argue it in kind of two different directions, right? On the one hand, there are very few government officials besides police whose lives may depend on the decision that they make in the moment. And I want to be really clear. I have friends who are police officers. I have relatives who are police officers. I understand very well that sometimes they really do have to make difficult decisions under conditions of uncertainty and risk. And I recognize that, I respect that. So on the one hand, you could imagine police saying, hey, we're the last ones who should lose this defense of qualified immunity. On the other hand, you can flip that around and say that most of the time, most of the kind of high stakes interactions that people have with government officials tend to be with police officers. You're not probably getting into it with the person who messed up your driver's license application at the DMV. I would say the most challenging question or the most interesting application here is with education officials, because that if your kids, for example, are enrolled in a public school, you are likely to have a significant amount of interaction with public education officials. They do sometimes have to make decisions that can have a significant impact on people's lives. There was an example just a couple of days ago where a young man, I think he was 12 years old, picked up a toy gun that said like zombie hunter on the side and had like, it was bright orange and green, and happened to be on screen for just a few seconds while he was doing remote schooling. And his teacher reported that to the police, who then went to his house. Now, fortunately, that incident did not have an unhappy ending. Well, it probably did for the kid, but there was no violence involved. That could have gone down much differently. And the question would then arise, I think, or could arise, what role did that teacher play in that outcome? I don't have a really fixed view about this. To me, these are questions that apply more or less at the margin. But I do think the most important thing to keep in focus is that the government officials to whom we delegate the most power over our lives, the most authority, the most discretion, are the ones who should be the most accountable to us. And I would say sort of the less power, the less discretion, the less of a concern there is. And I certainly am not going to haggle over sort of questions at the margin about whether, the local librarian should be covered by qualified immunity or not. But I'm absolutely and emphatically of the view that police should not be clothed with qualified immunity. And thanks again for the question.
All right, we're coming close to the end. We'll probably have time for a couple more questions. This one comes from Stuart. Professor Neily, do you have thoughts on the cognitive dissonance in conservatism between skepticism of state power and the simultaneous willingness of many conservatives to let police abuse their state power and then use QI as a shield and justification for that behavior? Why the internal inconsistency?
Yes, I do. I do have many thoughts about that. It's a great question. Look, I don't think any of us should lightly accuse others of hypocrisy, and certainly not before taking an inventory of your own potential inconsistencies. All of us, I suspect, are inconsistent to some extent in the views that we hold. But at the same time, I do think it's fair to highlight and underscore when people appear to be inexplicably inconsistent on really high stakes issues. And I do think the question of how accountable police should be is a high stakes question. And I do perceive a certain amount of inconsistency where you've got conservatives who, as a sort of a philosophical matter, purport to embrace limited government. They have great skepticism about the efficacy and legitimacy of government in various settings. But then when it comes to police, they seem to have, sort of I don't know whether to call it a blind spot or to be sort of nearly infinitely forgiving. And all I can say is that my hunch is that at least one explanation for this this inconsistency is that on the one hand, the police absolutely have an important role in society, or at least I believe they do. Even as a libertarian, I really do believe that police have an important role. I think there are people out there who are dangerous and scary. Somebody needs to confront those people, and we should support police when they're engaged in conduct that genuinely makes our community safer and better. And to a certainty, some of them, perhaps even most of them, most of the time, are doing that. And I think conservatives, tend to be mindful of that, and I think that's perfectly fine. But I do think they are unduly forgiving. Let me give you one example. This idea that qualified immunity only comes into play when police are making sort of snap judgments in the field is just not true. My former employer, the Institute for Justice, had a cert petition denied this past spring, where what happened was the police were in pursuit of a suspect. He was actually they were in pursuit of him because he had fled a court date, and they thought he might be inside his ex-girlfriend's house. And she said, well, I'm pretty sure he's not. But they said, well, can we just go in and have a look around? So she grants consent for them to go in and just search the house to see if he's there. And over the course of a couple of hours, they make several phone calls back to headquarters where they talk to a police lawyer about what tactical techniques they can use in searching this house. And what they finally come up with is that they're going to throw a bunch of incendiaries into the house, flashbang grenades. They throw them into the house, nearly kill her dog, set the house on fire, practically destroy it. And then when she sues, they say, well, you gave us consent to search your house. And their argument is that after multiple consultations with our lawyer, we thought that the scope of consent included throwing flashbang grenades into your house and nearly burning it down. That's preposterous, but it tends to be the kind of thing that unfortunately we do see conservatives embracing and saying, well, we don't want to second guess them. Well, that's easy to say when it wasn't your house that got burned down. It's easy to say when it wasn't your son that got shot in the back. And I think it's not probably a coincidence that conservatives of the kind who hold the kinds of views that we've been talking about probably have the least interaction with the criminal justice system as compared to other communities. Again, probably not a coincidence.
All right, our final question comes from Cody. Justice Gorsuch often talks about how the constitutional amendment process is designed to only permit changing the constitutional structure for issues that virtually everyone agrees on. In recent years, it has looked like almost no issues reach that level of agreement, but do you think that qualified immunity reform might possibly reach that level of agreement to feasibly have a workable constitutional amendment?
Yeah, that's a good point. So let's leave on this note. The good news is we don't need to amend the Constitution in order to get rid of qualified immunity because, again, it purports to be a statutory interpretation. It purports to be an interpretation by the Supreme Court of Section 1983, and they are reading into it what they consider to be a kind of a pre-existing background defense that sort of we should assume Congress meant to incorporate within the text of Section 1983. So there's no need to amend the Constitution to get rid of it. The big problem, I would say, is this, and my colleague Emily Eakins at Cato has recently did a survey in which she documented that 67 or 68% of Americans oppose qualified immunity. So there is clearly a supermajority of support for getting rid of it. One of the biggest problems, and this is something you should absolutely understand, it's a good note to end on. You may sometimes hear police and prosecutors, when they're criticized for enforcing a particular law, say, well, I don't make the law, I just enforce it. That is one of the most malicious falsehoods that you can ever hear in public policy. That is absolutely false. In reality, the law enforcement lobby is the second or third strongest in the country. They are an extraordinarily powerful constituency, and they spend a great deal of time and energy and resources lobbying state and federal legislators. The Department of Justice has an in-house lobbying shop called the Office of Legislative Affairs. So the idea that they do not exert influence over the legislative process, over policymaking, is a fantasy. And I would say that the number one issue for many members of law enforcement is to maintain the near zero level of accountability that qualified immunity provides them. So we're talking about a supermajority of citizens who want to get rid of qualified immunity going head to head with arguably the second or third strongest political lobby in the country, for whom zero accountability is one of their most important issues. How that's going to shake out, I think we'll just have to stay tuned and see. But I am very encouraged by the direction that I see the country moving in on accountability, on getting rid of qualified immunity. And I think if I had to bet, I would say that the law enforcement lobby is going to lose this particular effort to maintain and prop up a regime of near zero accountability in the face of a supermajority of citizens who want to get rid of it. On that note, thanks so much. I've really enjoyed the event, and I hope you have as well. Thanks so much to Sydney and Alex for having the opportunity to speak to you today.
Thank you again, Professor Neily, for joining us. And thank you, all of you. I'm sorry we weren't able to get to all of the questions, but this is a really wonderful event. And I want to thank you all and Professor Neily again for joining us.
You bet. And I'll say one more thing. If you have questions that weren't answered, go to unlawfulshield.com. Unlawfulshield.com. We have an FAQ that's the most comprehensive resource available on the web, and we might answer your question there.
All right. Thank you, everybody.
Bye-bye.